Copyright disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing nonprofit, educational, or personal use, tips the balance in favor of fair use. Okay, you guys. Obviously, I'm not going to be reading this on my phone. Scientology's history of criminality. I wanted to read this a long time ago, and especially directed at the LAPD, Clearwater PD, Chi-Town PD, Boston PD, just so they're aware of the criminality of Scientology. In case they didn't know, now they know. From gr0nd at alpha.c2.org, dated Wednesday, April 26th at 13:33:56 p.m. BST 1995. In 1979, 9 of Scientology's top executives pleaded guilty to extensive burglaries, forgeries, infiltration, obstruction of justice, and other crimes against more than 100 federal agencies, including the Department of Justice, the Department of Defense, and the IRS. In U.S. versus Helt et al., the facts showed that church personnel had secreted a documentary evidence of crime, 688 F as in Frank, 2D at 1243, N8, had committed illegal break-ins and theft, had electronically bugged government offices, had lied to federal investigators and a grand jury, had subjoined perjury, had forcibly restrained, kidnapped, handcuffed, and gagged children. Oh, no, wait, no. A potential adverse witness, and had formulated conspiracies to obstruct justice, steal government property, burglarize, bug, harbor fugitives from justice, and commit and suborn perjury before the grand jury. In a memorandum urging stiff sentences for the Scientologists, federal prosecutors wrote, "The crime committed by these defendants is of a breadth and scope previously unheard of." How about that, LAPD? No building, office, desk, or file was safe from their snooping and prying. No individual or organization was free from their despicable, conspiratorial minds. The tools of their trade were miniature transmitters, lockpicks, secret codes, forged credentials, and any other device they found necessary to carry out their conspiratorial schemes. Yeah, think about what the children go through, government, LAPD. You guys okay with that? Inquiring MF minds want to know. In England, the inquiry into the practice and effects of Scientology, prepared for the House of Commons in 1971, produced a ban on Scientology that lasted several years. In 1977 in Denmark, known for its tolerance, Scientology lost its protection contained in the Criminal Code of Justice concerning the protection of religion. In 1982, the full Supreme Court of Victoria, Australia, ruled that Scientology was not a religion or a religious institution, but a sham. The court ruled Scientology was a body formed for an object that was illegal under criminal laws. See Church of the New Faith versus Commissioner of Payroll Tax. Decided May 5, 1982. Also see the Anderson Report of 1965, Victoria, Australia. In the mid-1980s, France convicted L. Ron Hubbard in absentia for fraud. In 1988, in Milan, Italy, 76 Scientologists were committed for trial, charged with offenses from fraud, medical malpractice, and criminal conspiracy to extort money. to unlawful detention. Still consider that a religion, United States government? Other governments of the world? In a massive raid in 1990, Spain arrested 71 of the top international leaders of Scientology on charges ranging from fraud to tax offenses. The charges alleged involvement in forgery of public documents, coercion, labor law violations, and illicit association. On July 6, 1990, France arrested 6 of the top officials of Scientology in France for the illegal practice of medicine and fraud. If one was observing only renegade criminal activity of one or more adherents, Scientology's criminal history could be less relevant. Here, though, these activities are part of the secret written policies of the group. As the FBI and IRS have repeatedly uncovered, Scientology's actions and policies were created, approved, and ordered by the highest levels of the organization, like prestigious executives like Michael Rinder. These are the day-to-day activities of Scientology, not renegade or ad hoc, aberrational acts of individual employees. Like children, troll. Like children, troll. In spite of Scientology's never-ending spewing of subsequent damage control cover stories. Stopping the black PR. This is a criminal organization day in and day out. It makes Jim and Tammy Baker look like kindergarten. So says Vicky Asnaran, one of the 6 top executives in Scientology, until her defection in 1987. I'm always sus of those people, to be honest. Pervasive pretext religion in Scientology. A pervasive pretext standard is used to maintain balance between not passing judgment on the value of verity of a claimed religious belief. On the one hand, in preventing abuse of the liberality of the functional definition of religion. On the other, an effective way to show pervasive pretext is through literature not offered by the other side. That's really wordy. I don't even know if I understood it, to be honest. Scientology's public origin. Pervasive pretext is not found just in Scientology's secret materials. One can see it in Scientology's public origin, history, policy, and doctrine. Scientology and its alter ego, Dianetics, did not and do not always claim to be a religion. Does it make you wonder how Dianetics got to be a so-called #1 bestseller? Wakey, wakey. Scientology had its earliest origins in the article entitled Dianetics, the evolution of a science, which L. Ron Hubbard published in the May 1950 issue of Astounding Science Fiction magazine. I think that's the mockery, to be honest. You know, the mockery that here's a science fiction writer and now he's head of a religion. You guys get the mockery. Dianetics was described in this article as an organized science of thought, which offered a therapeutic technique for the treatment of any and all inorganic mental and organic psychosomatic ills, with assurance of complete cure. Isn't that illegal, you guys? But what do I know? In unselected cases, the science of Dianetics became further developed in subsequent writings by Hubbard and others. This development was solely scientific in nature and religious aspects were not present. In 1952, Hubbard abandoned Dianetics as such and began to concentrate his energies on Scientology. Scientology was viewed by its followers as a science much broader than Dianetics and concerned with knowledge in general, while Dianetics dealt mainly with psychotherapy and the mind. Nevertheless, the two were quite similar in practice. The founding church case involved an effort by the federal government to condemn Scientology's e-meter under the food and drug laws. Imagine that, you guys. The issue was one of mislabeling, and the government was required to show false secular representations regarding the use and benefits of the device. In that case, the government made no effort to attack the good faith of the religious representations involved. Thus, the court expressly refrained from making certain holdings. One, we do not hold the founding church is for all legal purposes a religion. Any prima facie case made out for religious status is subject to contradiction by a showing that the beliefs are not held in good faith by those asserting them, and that forms of religious organizations were erected for the sole purposes of cloaking, that's very secret society, a secular enterprise with the legal protections of a religion. The case was then retried, and an opinion issued by the district court entitled United Stags versus Article of Device, etc. 333. You guys know. You guys know. You guys know. F as in Frank, Sup 357. Dated 1971, the court stated. The bulk of the material is replete with false medical and scientific claims devoid of any religious overlay or reference. Imagine that. The court's opinion directly and forcefully confronts the issue of claimed First Amendment protection by Scientology. The court then held that the practice of Scientology was secular. Imagine that, you guys. When the commissioners of the city of Clearwater, Florida, convened public hearings on Scientology on May 5th through the 10th, 1982. They received documentary and testimonial evidence with respect to the operation, activities, and conduct of Scientology. Based on the sworn testimony of witnesses, affidavits, state and federal court decisions, and miscellaneous documents reviewed and considered, the Commission made the following factual recitation. Evidentiary fact. The Church of Scientology is currently engaged in a nationwide conspiracy to impede and obstruct municipal, state, and federal taxing authorities. How about that, City Council of Los Angeles? Federal Bureau of Investigation should be investigating LA and Clearwater by adopting a religious and charitable guise to avoid payment of taxes. You know, Scientology is not the only one doing that. Scientology's internal policy states, churches are looked upon as reform groups. Therefore, we must act like a reform group. Volume 1, page 196. They, the public, want ministers. We will show them what ministers look like. By the way, I want to interject. You guys know I was reading something a few days ago in which the alleged ecclesiastical leaders in real time in 2025, right now as we speak, are hiding and coaching victims that are children that were subjected to sexual abuse as children. Right now, LAPD. Scientology has nothing to do with religion. The church did not adopt their religious guise until it was necessary to seek First Amendment protection. The church uses ministerial garb to convey the appearance of religion. Church policy instructs members to lie, hey troll, to lie to inquiring officials. Scientology's expediently developed checklist, religious overlay, is not the result of a sincere religious evolution, but of Scientology's reactions to court losses, increasing liability for antisocial activities and other negative legal confrontations. At the commission hearings, L. Ron Hubbard Jr., the son of Scientology's founder, who had been a top-ranking Scientologist, prestigious executive, testified that the reason his father began claiming Scientology as a religion was to escape problems he was having with courts, the IRS, the American Medical Association, and to make money. From Wollersheim versus Church of Scientology of California. Number Charlie 33. There's the 33 again, you guys. It must be a conspiracy. Number Charlie 332827. California Super. 1986. Exhibit number 269. Hotel Charlie Oscar. PL 29, October 1962 religion. Okay. Scientology 1970 is being planned on a religious organization basis throughout the world. This will not upset in any way the usual activities of any organization. It is entirely a matter for accountants and solicitors. It's hard for me to see where I'm at on this tiny, tiny screen. Okay. Wollersheim's evidence disclosed that Scientology's hierarchy concocted a religious front for financial, legal, and public relations advantages. The religious front was to be used as a safe point. How about that, LAPD? To obtain favorable tax status and to present a favorable PR image to the courts and to the media. The religious front was to be used as an immunizing legal and PR shield whenever Scientology was criticized or sued for its dangerous conduct. What do they whine and cry about now? Freedom of religion. We have freedom of religion to abuse and exploit and neglect children. That's our freedom of religion. It's my opinion and I'm sticking to it. You can tell I watch BJ Investigates. Okay. No words better reflect the true place of religion in Scientology's scheme of things than those of its founder. On April 10th, 1953, L. Ron Hubbard, in a letter to Helen O'Brien, a Dianetics and Scientology franchise holder, said, "We don't want a clinic, we want one operation, but not in name. Perhaps we could call it a spiritual guidance center. We could put in nice desks and our boys in neat blue with diplomas on the walls. You know, children. And one, knock psychotherapy into history, and two, make enough money to shine up my operating scope, and three, keep the HAS, Hubbard Association of Scientologists, solvent. I await your reaction on the religion angle. In my opinion, we could get worse public opinion than we have had or less customers with what we have got to sell." That's not a charlatan. Just 7 months later, on December 18th, 1953, the Church of Scientology, the Church of Human Engineering, like social engineering, and the Church of American Science were secretly incorporated by L. Ron Hubbard. L. Ron Hubbard Jr., Ron Jr.'s wife, and 3 others. How many crimes have we seen so far, you guys? Those who seek constitutional protections for their participation in an establishment of religion and freedom to practice its beliefs must not be permitted the special freedoms this special sanctuary may provide merely by adopting religious nomenclature and cynically using it as a shield to protect them when participating in antisocial conduct that otherwise stands condemned. Pervasive pretext in the present Dianetics today. Selling the Dianetics book is a basic method used to start new people into the secret Scientology. It's the indoctrination. Bridge Publications, a Scientology affiliate, spends upwards of $10 million a year advertising Dianetics on television and in the print media. For a single book promotion, this budget is unprecedented in the publishing industry. See Hubbard Not Author Status Called Illusion. San Diego Onion, April 15, 1990, by Mike McIntyre. If you have ever seen any of these ads, you may recall their complete lack of religious context. Nowhere do they say that the Church of Scientology is the source and benefactor of these ads. You might also recall the promotion of Dianetics as a science, a mental health product, an implied psychotherapy, and as a provider of social science like secular belief benefits. From the Clearwater Commission report, the practices of Scientology undoubtedly constitute psychotherapy. Among the various psychotherapeutic claims of Scientology are increased IQ, lies, increased interpersonal communication skills, lies, improved memory, freedom from neurosis and anxiety, marital and family harmony. Can you imagine that, you guys? And cures for drug addiction. All of these benefits are claimed to be achieved in a process of auditing identical to psychotherapy. An auditor on a paid hourly basis, like a child, troll, like a child, interviews a pre-clear person receiving services intensively about the details of his emotional life while using a lie detector, the E-meter. To sharpen his questioning, the auditor keeps notes of everything that is said, like a child. The entire process is represented as having a scientific basis and stated to be the product of research. The pre-clear is told that the process, if carried through, is guaranteed to achieve, at the time of the first contact and the formative first impression, Scientology deliberately conceals its claim to religious status. Through Dianetics, it advertises benefits and cures outside of a recognizable religious domain. The ad scripts do not read, "The Church of Scientology proudly announces Dianetics, the religious science of mental health." Review of current Dianetics ads shows Scientology's ongoing, pervasive pretext. Though Dianetics is a fundamental come-on into Scientology, it fails to maintain a clear, obvious, and coherent front of religious context, and religious when presenting its views to attract new members. Belief in Scientology and Dianetics is held out in such a way that it could be totally predicted on scientific standards, e.g. science, scientific research studies, and comparisons of its effectiveness with psychotherapy. Stated from their documents in the Hubbard Information Letter of 12 April 1961, revised 14 April P.E. handout submitted as evidence in the Wollersheim case. Scientology auditing is today the only validated psychotherapy in the world. Scientology is a precision science. Scientology is the first precision science in the field of the humanities. The first science to put the cost of psychotherapy within the range of any person's pocketbook. The first science to contain the exact technology to routinely alleviate physical illness with predictable success. Imagine that the evildoers go after just everyday people trying to use naturopathy and home holistic medicine. But they're okay with this one. Think about that. These are representations usually strongly associated with non-religious perspectives, perspectives which one normally finds discussed in the particular contents of other disciplines. The content and context of Dianetics promotion is convincingly secular, suggesting competition with businesses providing psychiatric, psychological, or social services. It started out as business. Still is, you guys know. With Dianetics, Scientology drops its religious cloak. There's the cloak again, you guys. Is that a secret society reference? Because they wear cloaks in their rituals, right? Drops its religious cloak to recruit young, troll, young and naive new people. Another code for children. Young and naive new people into Scientology, When needed in the courts or elsewhere, Scientology pulls the religious cloak, there we go again, and shield back up again. Whenever false curative claims are not made in a religious context, the government has a responsibility to protect the public. Representations that are presented as verifiable from some non-religious perspective can be considered fraudulent if most people in a common sense way or in a way informed by the various disciplines would find those representations to be false. It is a gross exaggeration to insist that the energetic, persistent solicitation of e-meter audited cures for a fee has all occurred in a spiritual setting without use of a secular appeals and false scientific promises made in a wholly non-religious context. Besides failing to challenge the alleged fraud in Scientology's original establishment, the government has consistently failed to challenge how Scientology presents its representations to the public. When public due diligence finally takes place, it should consider the misleading and contrary bait-and-switch practices of Dianetic Scientology. It also should take into account coercive persuasion methods used by Scientology on its membership. Such investigation will produce the grounds upon which to legally challenge the good faith and sincerity of Scientology's representations. Verifying religious sincerity may be difficult, but subtle and difficult as the inquiry might be, it should not be avoided because of convenience. USCA Const amend? I don't know what that is. 1. I want to say Constitution, but I'm not sure that's it. In 1980 and 1981, I was assigned to lead the mission corporate category, Sort Out Project. The purpose of this project was to restructure all church-related entities in a way that it would make it clear that L. Ron Hubbard was not the alter ego of Scientology and in control of all Scientology organizations. Is he trying to get out of something here? Numerous proposals for this restructuring were developed and discussed by high officials of the church. Legal advice was also sought to ascertain whether the restructuring could be accomplished legally. The project dragged on for longer than necessary because of a disagreement I had with David Miscavige. There we go again, you guys. It's always little Davy, isn't it? I was unwilling to restructure the church in a fashion whereby L. Ron Hubbard could continue to assume control at any moment. I determined that for L. Ron Hubbard's own safety, he should sever all controls. Yeah, they're trying to get him out of all this responsibility. Just like a narcissist. You guys know what's up. Miscavige insisted that L. Ron Hubbard be able to maintain control because he was going to step into those footsteps eventually. Therefore, Mission Corporate Category Sort Out was disbanded and Mary Sue Hubbard removed, and Terry Gamboa and Norman Starkey hired new lawyers. On L. Ron Hubbard's instruction, and they fashioned the structure in place today. Just want to interject, too. If anybody wondered why Mike Rinder was so familiar with all the legal terms, think about that one. Why he never saw a day of jail's beyond me. I just say that rhetorically, because you guys know. The IRS final adverse ruling of July 8th, 1988 to Church of Spiritual Technology, COST, states on page 4, Mr. Hubbard died on January 24th, 1986. Like I said, Miscavige wanted to make sure he had all control. But his death did not alter the history of Scientology's prior operations. Moreover, the same individuals who controlled Scientology operations prior to Hubbard's death and who participated in arrangements which result in inurement and private benefit continue to control your operations and those of other top-level Scientology organizations after Mr. Hubbard's death. I bet little Davy was foaming at the mouth when he died. So ready to get all that control and power. Wait a minute, where am I here? Okay. Mr. Hubbard died on January 24th, 1986. but his death did not alter the history of Scientology's prior operations. Moreover, the same individuals who controlled Scientology operations prior to Hubbard's death and who participated in arrangements which resulted in inurement and private benefit continue to control your operations and those of other top-level Scientology organizations after Mr. Hubbard's death. Hubbard, in the end, was true to his well-known vow never to appear personally before any government agency. You guys know I have a lot of suspicions, but I'm not going to go into them here. I drop little hints here and there. He allegedly died in January 1986, 86 a death number too, just days before he was to appear in court on the Founding Church FBI case. His remains were rushed to cremation. Yeah, that's to hide evidence, because he was a drug addict. After a small-town autopsy, this was just days before reached a final unanimous verdict, favorable to Wollersheim after a 6-month trial. Damn, too bad LRH couldn't have lived to see his loss. It is kind of weird, though. Why is Wollersheim the only one that got that big win? I'm just saying. Maybe that name is important. I don't know. More from the MCCS tape transcripts. From the February 11th, 1985 affidavit of Jerry Armstrong, and I'm not a fan of his either. The whole purpose of the MCCS project was to defraud the federal government, litigants against the church, emphasis added, and the courts into believing Hubbard had no involvement with Scientology. Wait a minute. I'm just going to keep reading. On June 20th, 1990, the MCCS tapes were remanded from the Supreme Court. The Ninth Circuit Appeals Court in the Zolan case. I believe that's in Los Angeles. Reminds me of the Ninth Circle, but what do I know? The purpose of the MCCS project was to cover up past criminal wrongdoing. The MCCS project involved the discussion and planning for future frauds against the IRS in violation of 18C USC 371. Figures involved in the MCCS admit, on tape, they are attempting to confuse and defraud the U.S. government. What else is new? But yet it still goes on, right? That should tell you something. The IRS in Cost versus U.S. relied in significant part on the affidavit of Gerald Armstrong, who was authorized by the church to possess and transcribe the MCCS tapes. The defendant's proposed findings of uncontroverted fact of November 22nd, 1989 states, on or about September 28, 1980, a meeting took place in the Cedars Complex at Los Angeles, California, one of the corporate headquarters of the Church of Scientology of California, CSC. The meeting was attended by Charles Parcell, Deputy Guardian for Legal, DGL, at WW, who was in charge of all legal activities for Scientology throughout the world, and Laurel Sullivan, the personal representative of L. Ron Hubbard, a long-term senior executive, prestigious executive, of Scientology, and then in charge, IC, of a special legal mission, MCCS, which mission was seeking to conceal Hubbard's control of Scientology and develop strategies to effectuate actual control by Mr. Hubbard without incurring legal responsibility. That's what I said. I mean, you guys know that. I'm always looking at the numbers, too. What is the 47? Zachary K. Hubbard. In 1991, the U.S. Supreme Court remanded the Wollersheim case back to the California Appeals Court to review its previous reduction of Wollersheim's punitive award in light of its just completed Pacific Mutual versus Haslip ruling that allowed for the due process constitutionality of punitive awards. On the same day, the U.S. Supreme Court also ruled, as in the lower appellate court, that the MCCS tapes were now admissible as evidence. U.S. 89-1361. The Church of Supreme Court at the time of its Zolan ruling. The simultaneous rulings on both issues on the same day hardly seem surprising or unconnected. The Zolan MCCS tapes and the Scientology net worth in financial fraud issues were discussed in detail. How the fraud allegedly was effected through Scientology's corporate structure. In early 1980, Wollersheim filed suit against the Church of Scientology of California, which was the mother church of Scientology at that time. CSC contained the following assets, subsidiaries, and income-producing divisions within its corporate structure. The Advanced Organization of Los Angeles, AOLA. The American St. Hill Organization, ASHO. The Flagship Organization in Clearwater, FSO. The Publications Organizations, Pubs US. The Estates Organization, Estates. The Flag Operations Liaison Office, West US, FOLO, WUS. The Los Angeles Organization, LA Org. The Cadet Organization. The Cadet Organization, troll. Cadet. The San Francisco Organization, the United States Guardian's Office, USGO, financed by the U.S. Mission Network through the Guardian's Office worldwide. The Sea Organization Reserves, the Watchdog Committee, WDC, the ED International, ED Int, and the Commodore's Messengers Organization. Hold on 1 minute. By the time Wollersheim's suit came to trial in 1985, all that remained was a gutted CSC with almost no income-producing resources. The non-income-producing USGO remained after being stripped of its mission network income, but the stripped assets never left the absolute control, use, and benefit of those who had absolute control of the CSC at the time of the Wollersheim filing. The same individuals who created the new dummy corporate pockets to which the CSC assets were later transferred still control those corporate pockets. CSC gave away 90 to 95% of its assets through inflated, non-equitable, and bogus asset and liability adjustments and transfers. Scientology stripped out of CSC its most important income-producing and valuable assets during the 5-year waiting period for a court date in the Wollersheim case. The new corporations derived out of the CSC assets were formed with the specific purpose of removing those assets from CSC to defraud litigants. The courts in the state and the federal tax divisions, the new corporate purchasers of CSC assets, had full knowledge of pending tax and civil lawsuits in which losing was near certain and soon to be realized. Scientology management knew about their own torts and illegal activities in the Wollersheim and other cases. They knew that defeat was likely and imminent. In this context, Scientology deliberately used the new dummy corporate structures and fraudulent conveyances to those structures to attempt, among other things, to shield, extinguish, or lower punitive and other liabilities in light of California's defendants' net worth criteria for the determination of fair and adequate punitive liability. Artifices were planned and implemented to escape investigation and to mislead or hinder organizations seeking accurate information. From the decision of the California Appellate Court, 2nd District, 3rd Division, July 29th, 1991. And then they've got the court numbers there. In January 1980, fearing a raid by law enforcement agencies, Hubbard's representatives ordered the shredding of all documents showing that Hubbard controlled Scientology organizations, finances, personnel, or the property at Gilman Hot Springs. In a 2-week period, approximately 1 million pages were shredded. Isn't that destruction of evidence? What do I know? Pursuant to this order, subsequent events helped to prove Scientology's prior intent regarding its asset transfers. A revealing example in Scientology's inequitable non-market value transfer of an $85 million credit to Hubbard and a debt to Scientology. Scientology called this a backdated inventor's royalty for an e-meter that Hubbard never invented. This is reminiscent of a similar tactic that had been disclosed by the IRS in the founding church litigation. Probably the most covert form of compensation paid to L. Ron Hubbard was tithes, or a percentage of the gross income, which petitioner and other Scientology organizations routed to him in the guise of founding debt payments. Cleansing money, of course. Just like the mob. But didn't Ron Jr. talk about how Hubbard was working with the mob? How about that, LAPD? This bold level of fraud may be found in any transfer-by-transfer analysis of the disposition of CSC assets. The newly created non-taxable and taxable post-1980 Scientology corporations were organized, operated, and controlled in significant part as mere instrumentalities or adjuncts of the original, now stripped taxable or soon-to-be taxable CSC corporation. They became de facto subsidiaries, new corporate pockets that took over the assets of the original CSC subsidiaries for the purpose of evading legal accountability. But isn't it interesting how there's no fuss about all the abuse of the children? I'm just saying. Such massive fraud in nonprofit corporations can and should be exposed in the public interest. How about that, Los Angeles council members? From the MCCS tape transcript. There is no need at all for them to be the board of directors in order for them to run the church. Board of directors. Does that sound familiar, you guys? You guys can connect the dots. But the authority of the church has to lie somewhere and on some basis. And since the church has always chosen a corporate entity, eventually the authority is going to have vest with the board of directors. Another board of directors. The only reason it's worked so long without that occurring is because everyone has effectively been bound by the authority of LRH and have ignored corporate lines. Ignored ethics, ignored morality, ignored the laws, ignored everything. And nobody knows anything, do they? Charles Parcell, we could say that the RPF, Religious Research Foundation, RRF, and CSC are part of the same church, even though they are corporately different. I mean, if anything was a sham corporation, it's RRF. Alan Wertheimer, attorney for L. Ron Hubbard, answers, as I understand, its RRF receives monies that would otherwise be due to the California Church for services rendered by the California Church to people outside of the country who decide to pay the church from outside the country. Another way to cleanse some money, isn't it? CP, that's right. AW1, so that's basically right? That's right. Foreign non-U.S. Scientologists pay RRF. They go to flag the flagship org, FSO, and take the services from children troll. RRF was originally supposed to hold the money until the service was rendered, and then pay it to CSC. But in fact, it has not really done that, and so CSC has rendered much services to many foreign Scientologists, and RRF has got the money. Fortunately for us, RRF wasn't incorporated until 1973, and we're litigating 1972. So I haven't really tried to sort this one out, but it's obviously the classic case, loud laugh, of inerrant. If not fraud, several laughs. Laurel Sullivan says, well put. Unidentified speaker says, it's all privileged. Well, there we go, you guys. Dick Sullivan, the tape recorder is going here, Charles. Now, when you talk around a table like this and there is no Internal Revenue agent present, whispered, I hope so, bugged or otherwise, one can work out solutions. But when you are a few weeks away from a trial and everything you say is going to be rammed down your throat, then you have to start looking at what actually happened. And it's very difficult to assign significances to things other than what was actually being done at the time. The thinking here follows the policies of Scientology's founder, L. Ron Hubbard, who wrote a Treasury policy which was quoted by the IRS in the defendant's proposed findings of uncontroverted fact of November 22nd, 1989, in Cost versus U.S. The whole thing is to assign significance to the figures before the government can. The whole thing is a mess only because arithmetic figures are symbols open to any significance. So I normally think of a better significance than the government can. I always put enough errors on a return to satisfy their blood-sucking appetite and still come out zero. The game of accounting is just a game of assigning significance to figures. The man with the most imagination wins. From the affidavit of Jerry Armstrong, it is common knowledge among senior executives, prestigious executives, of the organization, and it is the policy of CSC that members of the boards of directors are mere figureheads. Right. Getting out of liability, anyone? Without authority or control. Like I said, getting out of liability. Not for internal corporate reasons, but rather to vest control in Mr. Hubbard. I have personal knowledge that in order to carry out this corporate fraud, organizational executives have engaged in the various unethical practices, including backdating phony board minutes and forging signatures. They must be friends with LAPD. It's my opinion. On pages 8 through 10 of the IRS's final adverse ruling of July 8, 1988, to Church of Spiritual Technology cost, the IRS tracks out part of the corporate shells, the unified management, and the asset transfer game regarding Bridge Publications, and the International Sea Organization Reserves Trust. These are two of the biggest assets and income producers. They were formed from the former Publications Organization, Pubs US, and the Sea Organization Reserves, that had been CSC subsidiaries but were stripped out from the assets of the Church of Scientology of California, CSC, during the Wohlersheim case. New corporations rolling in income and assets. By late 1985, a growing list of defectors from the highest management levels. Would that be children too? You guys know I'm being sarcastic. Accused Hubbard, now the Hubbard estate, of having stolen as much as $200 million from the mother church assets. Good. What is that old saying, there's no honor among thieves? This was just before his alleged death, and just as the IRS was seeking an indictment against Hubbard. According to Vicky Asnaran, who was involved in the evidence shredding, destroying evidence, and at the time was one of the 6 most senior, prestigious executives in Scientology. Scientology worked day and night shredding documents the IRS sought. Yeah, the LAPD is fine with that kind of behavior. But then look at what they do. In 1987, Scientology reported to the IRS that its new corporate entity and world headquarters organization, Clearwater, also created in significant part from CSC assets, had $206 million in a reserve pool. I wonder if that's the money they use to traffic drugs, because that's what Ronnie Jr. said. You guys know at the end, or at the top of the, In their May 6, 1991 cover story, Time magazine reported that COS, the new mother church, reported income of $503 million. That's from slave labor. In 1987, and that high-level defectors say Scientology has another $400 million in secret bank accounts. Notice none of them talked about the children. But maybe I'm in the wrong article. When examined closely, one will find COS using most of the assets of the stripped CSC and receiving income from CSC's previous leading income producers. That income is funneled through dummy and shell corporations, which are controlled by the same individuals who controlled CSC's assets before they were stripped out in fraudulent conveyances. These actions were committed with the foreknowledge and of approval of the highest management levels. Highest management levels, troll. On the Scientology organization. Nothing gets done in Scientology's robotic organizational structures without detailed orders and programs which, per policy, must strictly follow either Scientology's secret or public policies. Secret. Scientology's lawyers and accountants are necessarily aware of Scientology's criminal history. Most of the actions described here may have been committed with their complicity and knowledge, or at the least with their assistance through negligence in performing proper due diligence. Questions of individual embezzlement and breach of fiduciary trust must be raised concerning the key Scientology management principles and their legal and accounting representatives, particularly as regards to creation of the Hubbard estate and the new Scientology corporations. From the IRS's final adverse ruling of July 8, 1988, to Church of Spiritual Technology, Cost, pages 8 through 10. The past history of Scientology's operations suggests that the purpose of these organizations may be to disguise the fact that private interests are the ultimate beneficiaries of the reorganized operating structure. It seems that Scientology has temporarily figured out how to keep beating and making fools of the government, unless the government's involved. That's just my, thought. Adverse litigants and the tax people in getting new nonprofit religious exemptions after it has lost its old ones. They do this by changing the old mother church corporations into new mother church corporations and then transferring assets to the new entities. That's the oldest trick in the book. Their trick is to act faster than the justice system can complete litigation on its old corporations. You think government doesn't know? Come on, you guys. Scientology stays one step ahead by staying one corporation ahead of its victims and prosecutors. Allegedly. Moving fast in a slow and overloaded justice system is also the trick to deny the use of key evidences in the trial at hand. By taking numerous separate appeals to the U.S. Supreme Court, Scientology creates delays which effectively bar evidence, they still do this, from being used in present cases. If they lose on the issue at a later date at a higher court, as happened with the MCCS evidence in the Wohlerschein case, the trial is over anyway. In the Wohlerschein case, Scientology has been all the way up to the courts 4 or 5 times. Would have been nice to read a book by Wohlerschein. He probably had to sign one of those, NDAs? It's always the victim signing them, isn't it? Because of this asset and corporation fast shift game, government agencies and victims must demand receivership proceedings for Scientology now and demand that bonds be posted for their endless appeals. To do otherwise is to court disaster and the possibility of a religious version of the Robert Vesco flee the country with hundreds of millions in cash. That's it. I will leave a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night wherever you are. Peace.